It's on May 18, 2023 and August 24, 2023, temporarily enjoins and restrains.
Mr. Morisano, please read the Policy Committee's resolution.
Resolution to immediately repeal Board Policy 5756 in accordance with Board Bylaw 0131. Whereas the Hanover Township Board of Education is involved in litigation challenging certain aspects of the Board Policy 8463 and its accompanying regulation, and whereas during the oral argument on Wednesday, September 6, 2023, Deputy Attorney General James Michael specifically advised the Honorable Stuart Minkowitz, AJSC, that Board Policy 5756 is not a mandatory policy, and whereas the Honorable Stuart Minkowitz, AJSC, apprised the parties that Board Policy 5756 is not before him for consideration, and whereas the current temporary restraining orders issued by the Honorable Stuart Minkowitz implementing and/or giving effect to both Board Policy 8463 and revised Board Policy 8463 until such time as a court renders a decision on plaintiff's motion for preliminary restraints, and whereas the Hanover Township Board of Education recognizes that it must comply with the New Jersey law against discrimination, NJSA 10-5-1, which prohibits all forms of discrimination and affords all students, staff, and visitors statutory protection from any form of discrimination, and whereas the Hanover Township Board of Education recognizes that it must comply with the New Jersey Anti-Bullying Bill of Rights Act, NJSA 18A 37-13, which prohibits all forms of harassment, intimidation, and bullying, and affords all students statutory protection from same. Now there be it resolved that the Hanover Township Board of Education, based on the recommendation of the Hanover Township Board of Education's Policy Committee, immediately repeals the non-mandatory Board Policy 5756 in accordance with Board Bylaw 0131, and be it further resolved that the Hanover Township Board of Education will reaffirm the immediate repeal of the non-mandatory Board Policy 5756 at its next regular Board of Education meeting on September 26, 2023, in accordance with Bylaw 0131, and be it further resolved that the Hanover Township Board of Education will continue to fully comply with the New Jersey law against discrimination, NJSA 10-5-1, to ensure that all students, staff, and visitors are not subject to any form of discrimination, and be it further resolved that the Hanover Township Board of Education will continue to fully comply with the New Jersey Anti-Bullying Bill of Rights Act, NJSA 18A 37-13, to ensure that all students are not subject to any form of harassment, intimidation, or bullying.
Thank you. Can I get a second?
Second.
Thank you, Mr. Skiff. Is there any board discussion?
Well, I'd like to make some prepared remarks. I don't know if I should do that now.
I would do that after.
Because it's really for the public.
Yeah, I would do it after the
Okay.
vote.
Okay. Okay. Is there any other board discussion? Okay. Then roll call, please.
Dr. Wright.
Yes.
Mr. Omarisano.
Yes.
Mrs. Egbert.
Yes.
Mrs. Johnston.
Yes.
Mr. Skiff.
Yes.
Mrs. Domingo.
Yes. Okay. I would like to have a motion for the next set of public comments to be limited to 2 minutes. Can I get a second?
2 minutes each.
Yeah, 2 minutes each. Right.
Second.
Okay. All in favor?
Aye.
Aye.
Any opposed? Okay. All right, we're going to take a brief recess for 5 minutes, and then we'll come back for public comments and close the meeting.
We appreciate that. And I know there's been some questions, and some of you are wondering why the need for a special meeting to repeal a policy that's been in effect for a few years. So I hope to provide some clarity. At the last meeting, I promised that we would take every opportunity to do that, and so this is such an opportunity. Policy 5756, transgender students, is not a mandatory policy. This is distinct from, say, Policy 5512, harassment, intimidation, and bullying, which indeed is required by the law. My understanding is that where a widespread effort, that there was a widespread effort to misrepresent to school districts statewide that 5756 was mandatory, and that districts reasonably relied on those misrepresentations in adopting it. For anyone that has read it, there are a host of issues with the language and terms. For starters, its language is vague and ambiguous in many respects. Further, it is wholly one-sided in that it fails to provide a mechanism for the district to address and manage the competing concerns and interests of all students, parents, administrators and staff, and the district as a whole in these circumstances. The provisions which require duplication of records and maintenance of a confidential file, coupled with the quote confidentiality and privacy section, that fails to distinguish between disclosure to third parties and a child's parents, leaves open many questions. Based upon the Attorney General's prosecution of legal actions against us and other school boards, such as in Manalapan, Middletown, and Marlborough, these elusive provisions were likely created by design to avoid public scrutiny. Even now, the Governor and the Attorney General speak out of both sides of their mouths. They pay lip service to parental rights and then completely undermine those statements with lawsuits and other actions that seek to affirmatively exclude parental involvement and shackle any board from dealing with these issues in a compassionate and measured way that respects the various interests and rights of all who are involved. Thank you. While it is true that children have rights, there is simply no authority under the law against discrimination or otherwise that gives minor children an unfettered right of privacy to the exclusion of their parents. Conversely, the overwhelming binding authority from the Supreme Court of the United States right on down to our state law, as well as statutory federal and state law, demands that parents be apprised and have access to all information concerning their children, period. That is because under those same legal precedents, parents, and not the state, are presumed to act in the child's best interests. Putting these and perhaps some of the other issues with Policy 5756 aside, the policy itself targets members of a protected class and blatantly calls for differential treatment of transgender students and their families. Because of this, in my personal view, the policy violates the New Jersey law against discrimination. And while the current governor and attorney general may be proponents of this policy, it is our job as a board to look at it objectively through the lens of any future governor and attorney general, regardless of their political leanings. And when anyone does that in good faith, they can see plainly that the policy is ripe for legal challenge and blatantly exposes the district to liability for potentially withholding or concealing information from parents without a legitimate safety concern for doing so. Further, to the extent we could possibly attempt to rehabilitate the policy, the governor and attorney general have shown aggressive hostility towards any school board who has tried to do that. And in those instances, sought a court order requiring that they actually keep the voluntary policy in effect for the indefinite future. Shockingly, just last month, Judge Bauman in Monmouth County entered such an order. Thankfully, here in Morris County, Judge Makowitz confirmed last week and compelled the Deputy Attorney General arguing the case to acknowledge that 5756 is not mandatory. I will quote for you now the relevant excerpts from oral argument. The court, Mr. Michael, you are not debating that policy 5756 was a voluntary policy anyway subject to repeal by the board at any time, correct? Mr. Michael, correct. But what that policy does, and it follows the State Department of Education guidance, it basically, helps provide guidance for schools to basically navigate these various issues and sort of set out ways that they can be the court. True, but as I think you argued the first time, there are many districts around the state that don't have any policy whatsoever with regard to the issue, to maybe the statewide guidance. but there is not necessarily specific policy on the issue. Is that correct? Mr. Michael, I'm not sure about many. I know it is not necessarily a mandatory policy. It's mandatory guidance that the DOE was required to put, the legislature directed DOE to put out the guidance, and in this particular area, basically directed in large part what the guidance should say. So it is sort of an insight into the court. Guidance, yes, but, Mr. Michael, how the legislature views the issue, the court, right. But guidance, yes. Policy, no. Mr. Michael, right. But it is correct that this is not a policy that every district is mandated to have. The court, thank you. Our policy 8463, entitled Parental Notice Required, would require administrators and staff to notify parents when a child discloses an issue or exhibits behaviors that may have an adverse impact on his or her health, safety, or well-being. This common sense policy protects all children uniformly and in a non-discriminatory manner. It protects parents' rights to know what is going on with their children, and it protects the district from liability for failing or refusing to notify parents before it's too late. As it relates to Policy 5756, Policy 8463 strengthens, clarifies, and complements 5756 as to when disclosure of a transgender student's status must be made to parents. 5756 on its own is essentially silent on this important issue, and the Attorney General's contention in his court papers provides little clarity. Without citing any legal authority, he simply says, quote, schools can make disclosures in a number of appropriate circumstances, including 1, where a student does not object to disclosure, 2, where disclosure is necessary in the harassment, intimidation, and bullying context, or 3, where the school identifies a specific and compelling non-discriminatory justification for disclosure, including where there is a threat to student safety or a medical need for disclosure. And there's a 4th catch-all exception contained in the text of 5756 itself, which states, as allowed by law, implying nothing as to whether these exceptions are binding law or the Attorney General simply made them up. Doesn't 8463, which calls for notification when a child discloses an issue or exhibits behaviors that may have an adverse impact on his or her health, safety, or well-being, fall under, at a minimum, the 3rd and 4th exceptions deemed acceptable to the Attorney General? The Deputy Attorney General seemed to focus on the fact that 8463 creates an affirmative duty to disclose, but this is a red herring. Where the disclosure is indeed permitted, the board has the discretion and authority to take it to the next step and say, we want to require it. And that's precisely what we did with 8463. Our view is that Policy 5756, without the benefit of Policy 8463, is unacceptable in its current form. With no practical ability to modify it, without potentially subjecting the board to further legal action by the Attorney General, we have no choice but to reject it in its entirety. As Judge Makowitz has temporarily restrained the board from implementing 8463 until he decides whether to maintain those restraints or allow the policy to move forward, a decision we expect to receive in the next couple of weeks, we felt it appropriate to immediately repeal 5756. Again, without the benefit of 8463, 5756 is wholly inadequate to protect the district from liability and actually creates an environment with greater legal exposure. The state is not going to come to our aid, financially or otherwise, when we get sued by parents whose child, God forbid, harms him or herself, and the school had information and failed to act. The law against discrimination is the law of the land here in the state of New Jersey, and we intend to comply fully with it. Rather than referring to a policy riddled with unanswered legal questions and issues, our administrators and staff will be guided by our esteemed legal counsel on all matters that may implicate the lad. Further, the rights and protections currently in place for all students, including transgender youth, under our policy 5512, harassment, intimidation, and bullying, shall remain in effect as required by law. Notifying parents about their children's health, safety, and well-being is not discrimination. Involved parents do not harm their children, they help them. These are not controversial concepts. They have guided all public school districts for decades, and they will continue to do so here in Hanover Township. Thank you.
Thank you, Mr. Skiff. Okay, at this time, we open the floor back up for public comments. Please state your name, municipality, and group affiliation. If Mr. Giacobbe?
That's no more public comment?
No more public comments.
Just so we're clear, 8463 is only triggered if there is an adverse impact on a child's mental, physical, or emotional well-being. The cause, frankly, is irrelevant. The goal of 8463 was to notify parents when their child was experiencing emotional, psychological, or physical harm. That's it. Anybody who tries to spin it that it's to out, that's false. That's patently false. This board, this administration, does not tolerate any form of discrimination whatsoever. Let me say that again. This board, this administration, does not tolerate any form of discrimination whatsoever. All students, regardless of their race, religion, gender, sexual orientation, they are welcome here. And they've been welcomed here for decades, and it has worked. And I think that Mr. Skiff made it abundantly clear that 5756 in 3 districts is now, they're enjoined from doing anything with it. But I'm the person that argued the case. And when I argued the case, I made it abundantly clear over and over and over again that 5756 wasn't a mandatory policy. I knew it wasn't a mandatory policy back in 2019. Why? Because the law didn't mandate it. But it was passed because a certain policy company put out that it was mandatory. So let's be clear. 5756 was not mandatory. And during oral argument, which went on for over probably an hour, I continued to say it's not a mandatory policy. And finally, the judge asked Mr. Michael if it's a mandatory policy, and it was clear. You heard from the transcript. I have a copy of it here. Not a mandatory policy. It's a voluntary policy. And so this board, as the resolution shows, we absolutely will not tolerate any form of discrimination against any kid for any reason whatsoever. We won't tolerate bullying. It's not going to happen. But what we're going to also do is make sure that the laws, both state and federal, are respected. We respect the New Jersey law against discrimination with utmost sincerity. We respect the Anti-Bullying Bill of Rights. We respect the U.S. Constitution. We respect New Jersey Supreme Court and U.S. Supreme Court decisions. That's the law. And we have to look at the law in its totality when we treat other human beings. And the teachers in this district, and I think that people are doing the teachers from the certain comments are harmed. This board and this administration absolutely embraces the teachers. They value them. They absolutely respect them. The teachers serve as in loco parente. When the kids are here, they serve as a parent. And really what the whole purpose of 8463 was, which has now been temporarily enjoined, was not to have silos, but to have teachers and administrators and folks that work in this building working as a team with the parents. Because I'm pretty sure that when we work together, we get a lot more accomplished. I think we can all agree that what's going on down in D.C., they're not working together, nothing's getting accomplished. So that's the goal of 8463. And the repeal of 5756, if it's not mandatory, if it's voluntary, if it is a policy that is being divisive, that's just not acceptable. So that's why it was repealed. But let me be very, very bluntly clear. There's no form of discrimination that will be tolerated against any child, staff member, or visitor in the school district. And any kid who thinks it's okay to bully somebody because of their race, their religion, their gender, their sexual orientation, they're going to be sadly mistaken. And they will be dealt with, as this district has repeatedly, no tolerance for any type of harassment, intimidation, and bullying. So I wanted to end it there just so that folks are clear. This is not being repealed to be harmful. This is being repealed so that everyone, teachers, paraprofessionals, administrators, custodians, bus drivers, and parents work together for the best interest of all the kids. And for those rare circumstances, one gentleman spoke, where there are parents out there that aren't treating their kids appropriately, they're reported to DCP&P, which was formerly known as DIFUS, and they're reported to law enforcement. And in those rare circumstances where that happens, this district does it because all staff are mandatory reporters. And so we do have a fail-safe. If any teacher, when I say teacher, I'm talking about anyone who works here, if they have a reasonable belief that a child's going to be neglected or abused, once they make that determination, which could be subjective, they might be wrong, but once they make that determination, they are mandated to report it. They have no discretion. So we think that by repealing this, with the laws that are in effect in the state of New Jersey and in the federal laws, we are more than capable of continuing to protect and provide a non-discriminatory environment for all students, staff, and visitors to this district. Thank you.
Thank you very much.
That no one on this board has ever said anything anti-trans, anti-gay, anti-LGBTQ, nor have we asked anyone to do that. We have not called anyone a groomer, nor will we. We also do not divide. This is a very inclusive town, always has. The reasons for what we're doing has been stated before very eloquently by Mr. Skiff, which I believe has been posted. So if you'd like to understand why we're doing it, you can do that. It has nothing to do with any type of discrimination or hatred or anything other than that. Trans, LGBTQ, straight, everyone is welcome in this community. They will be treated the same. They will be given the same educational and resources that they need to succeed. And that is what we are here as a board to do. Thank you.
We wrote a policy to protect our most vulnerable, and we got sued. So that's what happened.
And there are three other districts that are being sued for changing the policy that you were just discussing. So we're not going to get involved with that. We do not turn a blind eye to LGBTQ. As we've said many times before, we include everyone. We are not anti-anybody. I wish that would just stop.
Bye-bye.
You can clap, but you can also leave if you don't like it. The other thing is, if you think that I'm proud and it makes me very happy to sit up here for hours and takes a sling and arrows from people who disagree with me after we make some very difficult and tough decisions that are required by us to make financially, legally, for the children, for the teachers, for the parents, for us, for everyone. No, we're not proud of what we're doing. We're doing what's right. There's a difference.
I'd also like to say that, I think speakers, Ms. Dunn, you have to be careful about dangerous rhetoric. Saying that we're shedding a blind eye to children or that we're abandoning children is frankly reckless and dangerous. Okay? We have a HIP policy in place. It's incorporated in the resolution that was passed at the special meeting that ensures no child is going to be targeted for harassment, intimidation, or bullying, regardless of their status, transgender or otherwise. So no child's being abandoned here. That's just a bald-faced lie. The other thing is, you know, it'd be nice if we could take 5756 and modify it to accommodate all of the parties' respective rights. But what the hostile governor and attorney general have shown to districts around the state that have tried to do that is, we're going to sue you, and we're going to make you stick with 5756 whether you like it or not, which is why everybody's repealing it now. So it'd be nice if we could do that. You should call the governor and ask him to allow us that privilege.
Mr. Skiff, you might want to also point out, as a member of the bar, we said this last time, there's a statute in New Jersey, it's called the New Jersey Law Against Discrimination. Somebody said it earlier. It does protect. It protects everybody. This board follows it, will continue to follow it, and will not tolerate any form of discrimination for students, for staff, or for visitors. Everyone is welcome in this district. And I said that last time. I said that, don't interrupt me, please. I said that last time, and this board stands firm with that. Again, they also, as Mr. Skiff just pointed out, the Anti-Bullying Bill of Rights. It's a law, mandatory law. We follow it. We don't permit any bullying whatsoever. The repeal of this policy, it was very clearly articulated during questioning by the judge that it is not a mandatory policy. If you try to change it, you will be sued. If you pass the parental rights or parental notification policy, you will be sued. Incredibly, our parental rights policy specifically says that you cannot notify a parent based solely on a child's protected characteristics under the New Jersey Law Against Discrimination. That wasn't good enough. We got sued. So the bottom line is, this is not anti-anything. This is a repeal of a policy that already was repealed. It doesn't exist anymore in this district. And the reason being is it has caused tremendous, tremendous dissension in our society. And frankly, if you don't repeal it and you try to change it, you will be sued. We're already being sued for passing a policy that was called the parental notification policy. And in fact, we had 5756. We had it on the books. We didn't change it. And we still got sued. So again, I think what Mr. Skiff said is exactly right. Go to your legislatures. Go to the Attorney General. Go to the governor and ask them. And I asked this question. If you're really opposed to parental rights, Attorney General, or if you're not opposed to them, as he said publicly, he said it on TV, I said, if you're not opposed to it, why don't you come up with a model policy that you can share with all of us? Because then we can pass a policy and not get sued. Guess what? We still don't have a model policy that's been promulgated by the Attorney General. I invited it, hasn't been. That was 3 weeks ago. So that's where people should go. Go back to the Attorney General, ask him.
Thank you, Matt. And I just want to add one thing, because I think it's very concerning. I think it's very concerning that we have people giving any impression to children in this district that they're being abandoned or that they're on their own. That is just absolutely not the case. There's also a policy, the mandatory, all teachers, all adults, frankly, in this state are mandatory reporters. Okay, so excuse me. Look, everybody just, if we could get through this, if everybody just respects one another. Okay? If somebody's speaking at the podium, they're going to speak, let them speak, we let them speak. If one of us are speaking, let us speak, let us finish what we have to say. You'll have your opportunity. Okay? But the fact of the matter is, every adult in this state is a mandatory reporter. If they have a reasonable belief that a child is subject to abuse or neglect at home, they have an obligation, an affirmative obligation to notify DCPP. That takes any parental notice policy, any parental notice required under 5756, it takes it out of that, and it puts it in DCPP hands, which is the agency that our state has given the task of making sure that these children are protected. We've relied on that mandatory reporting policy in every instance of abuse, regardless of what the reason is, for decades. So you can't have it both ways. You can't say, I don't think it's safe at home, but it's not that unsafe that I can't tell parents what's going on. It's one or the other, all right? And the mandatory reporting policy is still in effect in this district, and it still protects kids from abuse and neglect.
Thank you.
Thanks.
Thank you.
Yes, I do, because, people like to clap over me now when I speak for some unknown reason. You'll notice that when I do provide a clarification, it's when someone says something representing something the board has done action on or misrepresents what we are doing as a board. We have not gotten into anyone's discussions on either side other than that. When it affects the board and you say a misrepresentation of what we're doing, we respond. That's all.
We talk about the board and they
There's no talking. There is no talking from, there is no talking. Okay, thank you. You can, yes, good, sit. It's funny, they want us to follow rules and then they don't want to
Keep
follow
talking, you will
rules.
be removed. Stop.
That's all.
Jesus. Please, everyone
Okay,
stop
excuse
talking.
me, enough with the clapping. We are
You do
now
it again,
carrying
you're gonna get
on.
removed. No, you're not. Not right now. Someone's
You're
speaking.
disrupting.
One more time, you're getting removed. Watch it. Go ahead, ma'am.
with great acts to follow.
Okay, thank you. We're going to resume public comments. Thank you.
Lisa, before the next commenter goes, there was a comment made.
Folks,
Okay.
excuse me, the meeting's starting.
Thank you.
Thank you.
Before we broke, there was a comment made that suggested by repealing 5756 that we're leaving our teachers and administrators and staff with no guidance, and that's just factually incorrect. Our district,
Please.
our district, as has always been, will be guided by the law, including the law against discrimination, in any instances or circumstances that implicate the LAD and our council. So to suggest that by repealing 5756, we're leaving our administrators and staff and teachers with no guidance is just incorrect. And so I just wanted to correct that. Thank you.
Okay.
1 and 2 of the public relations agenda.
Okay, is there a second?
Second.
Thank you. Ms. Johnston, is there any board discussion?
No.
Okay. Roll call, please.
Mrs. Winkler.
Yes.
Mrs. Wilson.
Yes.
Dr. Wright.
Yes.
Mr. Marisano.
Yes.
Mrs. Egbert.
Yes.
Mrs. Johnston.
Yes.
Mr. Skiff.
Yes.
Mrs. Domingo.
Yes. Mr. Marisano for policy.
Upon recommendation of the superintendent, move to adopt numbers 1 through 10 on the regular agenda under policy.
Okay. Second?
Second.
Mr. Skiff, is there any board discussion? I actually have a statement that I'd like to make. All right.
I just want to say one thing to clarify. When I was arguing 3 weeks ago tomorrow, the Attorney General, in their motion, was trying to enjoin Policy 5756. And I got into a huge debate, and it was through that debate that the judge forced the Attorney General, Jim Michaels, to admit that 5756 is not mandatory. So the reason we took action is for that purpose, because they were seeking to enjoin it, just like they enjoined it in Middletown, Marlboro, and Manalapan. Incredibly, Middletown, Marlboro, and Manalapan wrote a letter to the AG, and they said, tell you what, because it's not mandatory, we'll repeal it, you drop the litigation. Do you know who hasn't responded to Marlboro, Middletown, and Manalapan? The Attorney General. So that's why the board repealed this policy. It's not mandatory. They were trying to enjoin us, and after we repealed it, they have filed a motion in aid of litigants' rights seeking to have it enjoined. That's what they did. So everyone should know that we repealed it because it's not mandatory, and the district was at risk of further litigation had it not been repealed.
Okay. Activist Attorney General, they are scared. Since our board's repeal of non-mandatory policy 5756 on September 11th, there have been numerous districts, as other people have stated, throughout the state that have repealed the policy and many more that are in discussion. Earlier this month, the Attorney General's office sent our board a motion filed with the court warning us if we followed through with the repeal of non-mandatory policy 5756, they would in turn seek to have our district pay their attorney fees. We have remained unmoved by their previous demands, and now in a desperate attempt to force us into obedience, they are threatening to punish us financially for something which was well within our legal right. In reality, what the Attorney General is doing is sending a message to all the other districts to toe the line and accept the progressive and novel idea that government schools can parent our children better than parents can. And if you don't accept this, our taxpayer-funded legal team will make an example out of you too. Hanover Board will continue to defend our common sense policy and encourage all districts to take their home rule authority back and reject the overreach of all progressive guidance that seeks to divide the family unit. We will support directly, indirectly, or passively any board who stands for these same principles and values. Thank you. Is there any other discussion?
No.
Okay. Roll call, please.
Mrs. Winkler.
Yes.
Mrs. Wilson.
Yes, but abstaining to one. I was out when it was repealed.
Dr. Wright.
Yes.
Mr. Marisano.
Yes.
Mrs. Egbert.
Yes.
Mrs. Johnston.
Yes.
Mr. Skiff.
Yes.
Mrs. Domingo.
Yes. Okay. All right. Can I have a motion for public comments to resume at a 2-minute limit per?
Just so everyone understands, policy 5756 was already repealed. It was repealed at the last meeting, the special meeting. All they're doing they're following board law 0131 just says that they're reaffirming the repeal. But it was repealed. It does not exist in this district. It's not on the website. So everyone who keeps saying don't repeal it, it has been repealed. Secondly, I've heard a lot about taxpayers. We have good news. The insurance company, my firm worked on it, reversed their decision. They're covering our legal defense costs in this litigation brought by the insurance. And we'll be submitting the bills that we've incurred since April when this litigation commenced.
I don't know how I follow that, but.